Okay. All right, gentlemen, whenever you're ready.
Good morning, may it please the court. My name is John Shahidi. I represent the appellants Bruce Bernstein and Apollo Munitions Research. Can everyone hear me okay?
Yes, sir.
Yes.
Thank you. I'd like to reserve 5 minutes for rebuttal.
All right.
Your Honors, this is an appeal from an order granting a motion to dismiss with prejudice and an order granting a motion for judgment on the pleadings, alleging that the appellees, the defendants below, were entitled to official immunity for defamation, even though this defense was not evident from the complaint and was based solely on the attachments to the motion to dismiss. The trial court adopted verbatim the defendant appellee's 12-page order, making factual determinations that clearly could not have been determined on a motion to dismiss. We'd ask this court to reverse. Briefly, because I know this is a very factually intensive case, but what happened procedurally here was that a government contractor entered into a contract with, there's some acronyms here, U.S. Special Operations Command at MacDill Air Force Base, otherwise known as SOCOM, to supply and source 6 million rounds of ammunition overseas on behalf of SOCOM. SOCOM then issued what was called an EUC, an end-use certificate, basically providing that the factory overseas would understand that this was authorized by the government. What happened was, through a number of issues, Mr. Bernstein and Apollo were familiar with this factory in Romania and had ammunition there. And as a result, there was some use of that factory was going to be used for this 6 million rounds of ammunition. There was an issue with whether there was actually those rounds of ammunition. And as a result, Mr. Bernstein and Apollo sent an email saying there's an issue with this. We have an issue with whether there's actually this ammunition, as it has been reported, we've got an issue with it, whether it actually exists. In response, the government contractor, aided by all of the defendants in the case, the appellees, sent back a letter, which we refer to as a SOCOM letter, in which the appellant alleges is defamatory. Now, the defendants, who are not government contractors, I want to make it clear, the government contractor and the subcontractor in this case are not parties to this appeal. The government contractor filed bankruptcy and the subcontractor was defaulted. The parties to this appeal are the individuals or parties that had no contractual relationship with the government. That's the allegation here, and there's no proof otherwise.
Well, your allegations, the allegations of your complaint allege that all of the defendants were procuring ammunition, correct?
That's correct.
Procuring ammunition for the U.S. government, correct?
Well, they were assisting. We're saying that
they're still involved in getting ammunition for the U.S. government, correct?
In one way or another, assisting. That is correct.
Okay, well, that's what your complaint says. And also, this is your amended complaint because the first one was dismissed. So this isn't the dismissal of an initial complaint. This is your second try, right?
That's correct.
Okay. And basically, your client is a competitor, correct?
My client also has ammunition at that.
Well, it's not a coincidence that he has the same type of business, right?
He has the same type of business. That's
okay, and he's not a party. He's not a party to the SOCOM contract, correct?
That is correct.
And your complaint, I'm just going by the complaint. I'm not going by the other, anything else.
That's
he
correct.
Inserted himself into and in between parties who had a contract, correct?
That's correct. Some
Okay.
who did and some who didn't.
Go ahead. You can go ahead and complete your argument.
The appellees did not have a contract. Now, I understand what you're saying, Judge Sleep, but the appellees did not have a contract with SOCOM. So none of the appellees alleged here had any relationship with SOCOM other than to assist, nothing further. In response to the defamatory letter, the appellees are alleging that they were authorized to send this letter for a couple of reasons. One is they were on the definition of a private contractor, and they were authorized to send this letter to notify the contracting officer of a breach because of an improper leak of sensitive information outside of authorized channels. Now, they make that allegation without any proof. They make an allegation basically on the SOCOM letter, which I'll go over, and a regulation, which is regulation number, let me get the number here. (5652.204-9003), which is called, for the purposes of this argument, a SOFAR regulation, and that's in the record at 83 through 84. And I wanted to address that because they're making their argument, simply argument of counsel without any evidence, stating that, one, that the appellees were authorized to send a letter to SOCOM based on this regulation. Now, when they filed the motion to dismiss and when they make their argument in front of this court, they allege that this regulation is titled Disclosure of Unclassified Information and Notification Requirements. However, it's obviously more detailed. The allegation, the title is Disclosure of Unclassified Information and Notification Requirements for Cyber Security Breaches. It deals with hacking, deals with information that is potentially taken from a computer. There is nothing here that would indicate that there is any hacking going on. What the appellees are alleging was their basis for the SOCOM letter was that the appellants were aware of the ammunition contract, and two, the appellants obtained what was called the EUC, the end-use certificate. Their allegation is that was improper. That's it. They aren't alleging any cybersecurity breach, but they're relying on the SOFAR regulation. And let me go over what they're relying on in the SOFAR regulation. The regulation states that all contractors, not private parties, not assisting, not marketing firms, all contractors supporting SOCOM are required to inform the contracting officer within 3 business days of when there has been a breach or successful penetration of the contractor's networks or information system. The appellees are relying on that solely in argument of counsel, saying that all the appellees, including the marketing firm and individuals, were, quote, contractors supporting SOCOM under this regulation. So they're making that first allegation that they're a contractor supporting SOCOM without any proof. Then the regulation goes in very detail regarding what breaches there are. In their motion and in their answer brief, they delete a portion of this SOFAR regulation. I'm going to read it. Breaches include unauthorized intrusions of the contractor's servers from external parties, whether through an introduction of malware, hacking, the compromise of access passwords, or any unauthorized access or compromise. Breaches also include the physical loss of storage, media such as disks, hard drives, and thumb drives, laptops or other devices which contain duplicates of information contained on the contractor's data system. They took that out in their motion to dismiss and in their answer brief on 4 to 5. They delete that. They rely on this language, or the willful or accidental transmission, copying, or posting of contract information, which has not been specifically authorized by the contracting officer. They rely on that. The problem with that is, again, that deals with cybersecurity breaches, but it also states that even if this regulation would apply, it applies only to posting of information which has not specifically been authorized by the contracting officer, which would be SOCOM. Nothing in here would indicate that anything that Mr. Bernstein or Apollo received, any information, was information that was not authorized by the contracting officer. Simply argument of counsel, nothing more. However, they rely on those two bases to show, one, they were all private contractors subject to immunity, and they sent the SOCOM letter pursuant to this regulation because there was a leak of sensitive information, relying solely on that. There's been no testimony, no depositions. All there are is the allegations from the motion to dismiss, not the allegations of the complaint. One step further in the SOFAR regulation, estimates of damages and mitigation strategies will be submitted to the contracting officer within a period following the breach specified and agreed on by the contract and the contracting officer. That flows from the allegation of a breach. Hasn't been done. And there's no allegation there was any estimate of damages. There's no allegation that anything on this SOFAR regulation was followed. And then finally, D states, the contractor shall include similar requirements to this clause in each subcontractor under this contract. Subcontractors shall submit requests for authorization to release and notifications related to cyber security breaches through the prime contractor and contracting officer. It's clear this dealt with cybersecurity breaches. There's been no allegation of a cybersecurity breach here. At most, there is a question of fact whether this SOFAR regulation would even be a basis for immunity, something that certainly cannot be determined on a motion to dismiss. Then let's turn to the SOCOM letter. That is the main basis for the defamation case. All the SOCOM letter, and it's in the record 75 to 79, the only relation between the SOFAR regulation and the SOCOM letter is reference. It references in the initial part of the letter to this regulation. What the defendants are trying to say through a motion to dismiss is they can cloak anything they say with immunity if they cite this clause. They're basically saying we have immunity without any explanation, without any more. We have immunity because we cite this clause, which I already stated to you has no application. Then what they allege in their motion to dismiss was this letter indicated that they were showing proof of a breach of wrongfully omitted information. But a review of this letter indicates it's nothing of that. It's not showing a breach. It's a letter of concern. Basically, all this letter, which is defamatory, is a response to Mr. Bernstein and Apollo's allegations. They don't say there's been a breach of sensitive information. They don't allege there's been a leaking of any information. They basically cover themselves and say that what Mr. Bernstein is saying is incorrect. There's nothing here to indicate the letter in its entirety does not try to explain a breach. It says a notice of concern, and it doesn't try to show that there was any sort of leaking of information that was not authorized. There's nothing in the record at this point to indicate that any information Mr. Bernstein received from any other source was classified or sensitive or leaked. However, what happened here was the trial court basically agreed with the defendants here in their motion to dismiss, and instead of construing the allegations of the complaint in the light most favorable to the plaintiff, it construed the motion to dismiss in the light most favorable to the defendant and adopted each and every allegation that the defendant appellees made. The order, which is verbatim from what counsel sent, which is signed 2.5 months after the hearing, alleges a breach, alleges basically what defendants are arguing.
Sir, I'm sorry to interrupt, but I just want to let you know you have 5 minutes left.
Okay.
You can use it however you wish.
Sure. And what we're basically saying, Judge, is by basically taking away by allowing the defendants to enter have the order entered verbatim, they basically, the trial court did not really review this properly, and it should not, a order granting a motion to dismiss should not have been entered. There is no question that we are certainly understanding of potential security issues with the government. That's not the issue here. The issue is based on what has been alleged in the motion to dismiss. Can that be the basis of an order granting a motion to dismiss with prejudice? We'd say absolutely not. There has to be discovery of the contracting officer. Did the contracting officer agree this information was sensitive? There has to be a lot of information from the prime contractor, Purple Shovel they're called. Did they agree that this information was sensitive or was improper? There's been nothing at this point, simply argument of counsel that the trial court agreed verbatim. So we request that this court reverse the order granting the motion to dismiss with prejudice and judgment of the pleadings, or on the alternative, which I don't think is necessary, to grant leave to amend. Thank you.
Thank you. Mr. McGuire?
Good morning. May it please the court. My name is Jim McGuire. I'm the attorney for the LS2 defendants, appellees in this matter. I'm speaking this morning, though, on behalf of all the appellees.
Okay.
Your Honors, as I heard counsel's argument, I think there were essentially two key points. He first focused on the issue of what's actually in the pleadings, and did the court look at those pleadings or look at something else? And then focused on what is the meaning of the so far's regulation. So what I'd like to do is address those two issues in that same order for the court, and obviously answer whatever questions the court may have. I think it's important, of course, to start with the premise that SOCOM, as we know, does work that's at the heart of American national security, as we demonstrated in our brief. They do work on things such as counterterrorism and unconventional warfare. What they do is critical to American national security. Now, the reason that immunity applies here is because the whole concept of immunity is that when you're dealing with an organization like SOCOM, if you've got a concern about national security, bring it to SOCOM's attention and let them figure out whether it's a problem. Don't let a jury figure out whether that's a problem. Don't let the plaintiff's lawyer figure out whether that's a problem. Let the organization that deals with national security determine whether this is a problem.
Well, Mr. McGuire, I'm sorry, go ahead, Judge Sleet.
You go ahead.
Mr. McGuire, I hear what your argument is on that point. The letter, the SOCOM letter does a lot more than just notify SOCOM of this potential breach of SOFARs. I mean, it's a point by point takedown of what they view to be fraudulent statements that were made by Mr. Bernstein, and questioning Mr. Bernstein's whether or not he's on the up and up. It goes a lot farther than that. Would you agree?
I would agree it addresses things other than the breach itself. Although everything it addresses flows out of that breach, because what happened here was Mr. Bernstein obtained this information from the Kujir factory in Romania, contacted Purple Shovel, made all these fairly outlandish allegations, and within one day, Purple Shovel did what the SOFARs requires, which is it sent a letter exclusively to the contracting officer at SOFAR. It invoked the provision in the at SOCOM invoked the provision in the SOFARs that says you need to tell us when there's been a breach, explained what that breach was at the bottom of the first page of the letter. And if I could quote from it, they say, Bernstein, quote, obtained information regarding our effort to source the required ammunition from Kujir, the ammunition manufacturer, and then goes on to say, and I'm not quoting here, but paraphrasing, we have no business relationship with Mr. Bernstein. He should not be involved in our contract or procurement efforts regarding this contract in any way. So they walked it right into what that provision is about, Your Honor.
But if you look at the allegations of the complaint, and I've never really seen emails attached to a complaint, but it's there. So you all waived. I don't know how, Mr. Shaddy, you have any kind of argument about going beyond the four corners of the complaint since everything was attached. It appears to me that you waived that argument. But the point I'm making is if this were a contract between private parties, you might infer a potential tort claim for interference with contractual relations. But we've got some different people here doing government work, and you're arguing a certain official immunity, but you're arguing that from everything that's attached to this complaint, that official immunity extends to others that from reviewing the documents, it's not apparent that they're covered by it. Your letter, the letter by Purple Shovel to SOCOM doesn't say that everybody's covered by it or that everybody signed an agreement to be covered by it. So how can a judge, I mean, the rule is, usually, generally, we get an adjudication on the merits and let the parties litigate this thing. And this may be a summary judgment type issue. But what I'm saying is, based on all the documents that are attached to this complaint, you're saying, well, that official immunity applies to these, what appear to be private companies.
Well, I am saying that, Your Honor, but only in this sense. There is one and only one allegedly defamatory publication in this case, is the publication of the Purple Shovel letter to SOCOM. The LS2 defendants and the other defendants didn't put this in the newspaper, didn't publish it to their friends. The only entity who ever contacted SOCOM about this event is Purple Shovel. And there is no factual dispute on this pleading that Purple Shovel had a contract with SOCOM that required Purple Shovel to report these types of breaches. What the plaintiff is saying is, even though the LS2 defendants, for example, didn't say anything to SOCOM, they're responsible for defamation because I'm going to tell the court the LS2 defendants and the ANSO defendants and the Purple Shovel defendants are one and the same for the purpose of this letter. However, they're not one and the same when we look at the requirements of the SOFARs and the immunity.
So the way that you square that circle is you make the argument to the trial court, Judge, this fails to state a cause of action against all of these defendants who, on the terms of the complaint, within the four corners of the complaint, were not signatories to this letter. They made no defamatory statement as a matter of law because it's just not there, and the exhibit belies the complaint's allegations to the contrary, and the exhibit trumps. That's the argument you take under that vein, not that, all of these people are immune if they have any connection with the contractor.
Well, Your Honor, I hear what you're saying there, but the plaintiff has pled this case in a way that he wants to have it both ways. So the Purple Shovel contract, or the Purple Shovel letter to SOCOM, is in the record and is incorporated in the complaint. And as I mentioned, it's on Purple Shovel letterhead. It's signed by Purple Shovel. It's not CC'd to anyone else. But the complaint alleges over and over again that the LS2 defendants and the ANSO defendants published the letter to SOCOM. So that's the plaintiff's allegation. And I'm saying is if that's true, if you're saying a letter by Purple Shovel in response to the SOFARs, in response to its contractual requirements, is actually a letter by anyone who was in the conference room helping draft the letter, who got on the phone and discussed the facts that need to go into the letter, if that's the case, then they're all immune. They have to be, because all of the immunity cases talk about the idea that what we're trying to do here is to discourage self-censorship. When you see something, say something. We're trying to discourage self-censorship in that instance. And if you say to Purple Shovel, you have immunity for the letter, but the individuals who work for you and your subcontractors, when they meet with you and help you formulate this letter, they're going to get sued, and they're going to have to defend that case all the way through to summary judgment or perhaps trial. That defeats the entire purpose of an immunity. And I think we cited some cases in our brief as well.
That's a pretty tall stretch, because actually, although the effects of immunity are profound and shut the courthouse door, effectively shut constitutional rights and courthouse doors on litigants, the ambit of immunity is we're supposed to take a hard look at that. We don't just willy-nilly grant immunity to private entities and to governments to do and say whatever they want with impunity. This is supposed to be a limited kind of thing that gets afforded for the purpose, because it advances some really important governmental interest, right? You're asking, your argument of immunity seems to throw open the doors and throws the net wide to anybody and everybody who happens to get named in a lawsuit that might have had a connection to this.
I don't believe that's true, Your Honor, because again, the only allegation here is that letter to SOCOM is defamatory. And what I'm saying is that letter to SOCOM is required by the SOFARs. And since it's required, the fact that the secretary in Purple Shovel's office may have typed up the letter doesn't mean that she has to defend against the defamation claim for that. Of course, she's part of that immunity. The letter itself is immune. And so those who prepared the letter are part of that immunity. By the same token, Your Honor, if you're saying to me immunity doesn't apply here, but based on the allegations in the complaint, the LS2 defendants and the ANSO defendants obviously didn't publish anything because their name's not on the letter, and therefore they didn't engage in any defamatory conduct, I'll take that. I'd be glad to win on that. But
yeah, but you didn't do that. That's my point.
But
that's not before us.
But what I fear is going to happen if the court takes that approach is we're going to go back down, and then suddenly we're going to hear the exact opposite side of this argument. Look at my pleadings. I say that LS2 published it. Granted, their name's not on the letter, and it's not their letterhead, but I alleged it. Therefore, the court has to take that at face value as well. They've pled completely contradictory things. We took the letter at face value. It says what it says, and there's immunity that attaches to that letter. And to say that the immunity attaches only to the actual person who put the letter in the mail, and it doesn't attach to the people who sat in the conference room and worked on putting the letter together, I believe significantly undercuts and undermines the purpose of the immunity. And so briefly to address the other issue that was raised, which is what is the meaning of the SOFARs? Counsel wants to tell you that the only types of breaches that can be reported are cybersecurity breaches, but that's not what the SOFARs say. They list 3 types of breaches. They list the unauthorized intrusion into the contractor's servers from an external party. That's a hack. They list the physical loss of storage media, such as laptops or thumb drives, but then they have a broader provision. They see the transmission, copying, or posting of contract information. And again, just taking this to its logical extreme, the plaintiff's argument would say this: if I'm Purple Shovel and someone breaks into my office and steals a laptop, I have to report that to SOCOM. If someone breaks into my office and I have 5 3-ring binders that contain all the information about this contract that's on my laptop, and they steal the 3-ring binders, but not the laptop, I don't need to report that to SOCOM. SOCOM won't care about that. That is absolutely illogical and irrational and makes no sense. And there's no reason why the statute or the regulation would be written in that way, and that's why it's not written in that way. That final provision doesn't tie it to any type of cybersecurity breach.
Well, the complaint, paragraph 41, alleges that Bernstein arranged for the defendants to visit the factory. That seems to beg itself for some discovery to determine that, whether there was some sort of agreement, oral agreement, that Bernstein would facilitate this visit with your clients.
I think,
So-
Your Honor, the complaint actually alleges that Bernstein had a relationship with an individual named Dale Woods, who is not one of my clients, who's not an employee of the LS2 defendant.
But I'm not saying it's true or not. I'm just saying you're supposed to take it as true that Bernstein arranged for your clients to make the visit. This is a curveball. So
Right, but-
you're saying official immunity. Oh, but yeah, we allowed Bernstein to set it up.
But the complaint doesn't allege that my clients allowed Bernstein to set up. In fact, it alleges that my clients essentially knew nothing about Bernstein. It was only when he reached out with this email that his involvement in this became known in any way to my clients. That's what their letter to SOCOM says as well.
Paragraphs 41 and 42 of the complaint allege otherwise.
Your Honor, my understanding is paragraph 42 alleges, and I'm trying to pull it up here, that
Looking at the amended
they
complaint.
essentially had no role in the process.
It says Bernstein arranged for the defendants to visit the factory. And then the person assisting Bernstein in arranging for and who was actually present during the inspection contacted Bernstein and advised him of what may have occurred there. So
Yeah, the person, and I think it's clear from the other attachments to the document, the person arranging for Bernstein to get into the factory is a gentleman whose name is, it's a Romanian name, Stroika, I believe, Raju Stroika or something like that. That's again in his email, which is part of the allegations as well. There's no allegation in the complaint that the LS2 defendants or Purple Shovel or ANSO or anyone else in this series of people who were contracting with SOCOM, that any of them had any connection with Bernstein or knew anything about his role in this. And I do think it's important, Your Honor, I realize I'm running short on time here, but to look at the information that was disclosed to Mr. Bernstein and that he revealed in his letter to the Purple Shovel party. He disclosed that he knew about the occurrence of the inspections. He knew where they occurred at the Kujir factory in Romania. He knew when they occurred. He knew the specific people who were there, including Eric Phillipson, Dale Wood, Purple Shovel employees. He had seen the EUC and he knew, therefore, that it was SOCOM that was seeking this ammunition overseas. He knew the type and caliber of ammunition, and it's a type of machine gun ammunition that's used in Russian-made machine guns. It's used by Russian and Chinese army. This is not a standard US military acquisition where you're buying nuts and bolts or you're buying even ammunition for American weapons. This is part of their counterterrorism or unconventional warfare work that SOCOM does. And it disclosed the exact amount of that ammunition that was going to be acquired. And the plaintiffs are saying, all of that can be disclosed to me, and you don't have a right to report that to Purple Shovel, to SOCOM. And if you do so, you're going to be subject to defamation liability. Your Honor, I think it absolutely undercuts the entire concept of why we have immunity for reporting these types of security concerns to the United States.
So is it your position, Mr. McGuire, that anything and everything in that letter necessarily flowed from the regulatory requirement that they disclosed to the contracting officer that there's been this breach, that there's been a disclosure? Everything in that letter.
Well, I guess I would say it this way. Once Mr. Bernstein in his email disclosed to Purple Shovel what he had learned about this acquisition process, and then coupled that with a series of false allegations about allegedly criminal conduct by the defendants over in Europe, of course there was an obligation to report both the breach and the context in which that happened, and to defend themselves and to say that that has not in fact happened here. But if you look at the immunity cases,
You think the defending yourself part falls within the ambit of immunity?
Well, it does, because the question here is, how did this breach come about? Who's at fault? The Purple Shovel party and the other defendants.
That's not what the regulation says, though. The regulation doesn't mandate independent investigation that lays out all the bill of particulars and responses to. It just says you need to disclose it and I'm taking you at your word on your argument, so that SOCOM can do the investigating.
Right. And presumably SOCOM did the investigation here. We don't have any information about what SOCOM did with this. But again, Your Honor, I would say this: if you look at the immunity cases, and we cited a long string of them in our brief, I don't think there's a single case where the court slices and dices the communication with the federal government and says paragraphs 1, 7, 9, and 11 are immune, but the other paragraphs discuss some other things. Therefore, we're going to deny immunity on
And
that.
all that might mean is that the letters got to the other letters that were before those courts got right to the point, did what they needed to do, and did no more.
Well, I think if you look at it, Your Honor, the facts in those cases suggest that there was, generally speaking, much more than that. That there were investigations that occurred, that were detailed reports that were filed with the United States government. None of those cases say this was a 4-sentence, recitation of these facts and nothing else. And I think that would take a decision saying that, I think, would take this court outside this sort of consistent stream of cases applying official immunity.
So if the SOCOM letter had concluded with a punchline that said, Mr. Bernstein is a felon and a liar, and in fact, he was neither, that would be covered under immunity, so long as it got tagged along with all of this, with the disclosure and the other context.
If
they could just put that out there.
If that letter was submitted solely to the contracting officer at SOCOM, like it was in this case, it was submitted within 3 days as it was required to be in this case, yes, that would be immune. I mean, that's the whole point of immunity, is you may get some fact wrong about the person you're reporting on. And the fact may be wrong and defamatory. And if it is, that typically would subject you to a defamation claim. But the cases say, we are not going to look into whether the allegation turns out to be right. The immunity exists at the front end when you submit that letter. And if the court were to say, well, let's look at the letter, we find something false and defamatory here, then the immunity doesn't exist. As soon as you begin that inquiry, you've eliminated the immunity.
I just wonder whether the inquiry is necessarily bounded by the regulation that you're invoking, so that the immunity only attends as far as what is necessary to fulfill the regulation. That's all I'm wondering about.
I'm not saying it can only go that far. I'm simply saying there was a contractual and regulatory obligation placed on Purple Shovel to report back to SOCOM. The fact that there was information that the court may view as not absolutely essential to reporting that breach, I don't think changes the analysis. And again, if you look at the cases never say, well, the immunity applies because we read the statute to mean precisely this. What they say is the statutes, the various Defense Department manuals, the things that parties are reporting under require a report. And if you make a report pursuant to that requirement, you're clear. There's immunity at that stage.
Sir, you're at the end of your time. Thank you very much.
Thank you, Your Honors. Obviously, we ask that the court affirm the decision below.
Thank you. All right, you have about 4.5 minutes, sir.
Thank you. Briefly, Your Honors, I want to make sure this court is not making an assumption that the appellees are, and because they're saying there's a breach. There's been no determination, though the judge made a determination as a breach. There's nothing in these documents that indicate there was any sort of breach. And more importantly, there's no presumption that the SOCOM letter was subject to immunity, even if it was sent by the contractor. They're making that presumption and saying it's immune. There's nothing in this letter based on a motion to dismiss, other than argument of counsel, that indicate that even the letter sent by the contractor was immune, because there's nothing to show at this point that it was subject to the SOFA regulation, which basically is up to the contracting officer. There's been no discovery of the contracting officer of whether they agree with this letter, an estimate of damages. There's so many other points that have to be raised here to even determine if there is immunity on behalf of the prime contractor. But we're not even there. We're saying that you can't even assume that, and especially you can't make a determination that others who are not the prime contractor, who we're alleging conspired to prepare this defamatory document are somehow also cloaked with immunity. Clearly, there are questions of fact. I think counsel's 10-minute dissertation explains to you how many questions of fact there are. Solely argument of counsel. There's been no evidence to support anything he's saying. This is not something that could be determined on a motion to dismiss. It's very clear that you need discovery from Mr. Bernstein, as Judge Sweet said. You need discovery from SOCOM. You need a lot of discovery to determine whether this regulation was even applicable. Whether SOCOM said this regulation doesn't apply. We don't know what you're talking about. Finally, the letter states, I'll conclude with the letter. The letter is not a letter showing a breach. The letter conclusion states, this correspondence is in an effort to provide you with real-time updates and also brief you on any current outside interference concerns we have in order to maintain fulfilling the contract in full and on time. It's not ahead of schedule. Nothing in this letter indicates a breach of sensitive information. The contracting officer would need to make a determination. As Judge Lucas, you said, there has to be an investigation by the contracting officer. Maybe this is proper on summary judgment, maybe not. But everything that Mr. McGuire is telling you would be evidence that has to be determined by this court. It can't be determined on a letter and on a regulation that the only party alleging this letter and regulation is immune is the defendants, without any sort of basis of facts or proof or evidence to support their allegations. This is a basic, very clear case of a judge basically adopting an order verbatim without making any independent findings on her own. To determine that the court would make these independent findings, these detailed independent findings, verbatim from what the defendant suggests is basically improper, and it basically shows that this order should be reversed. We request the order be reversed. At a minimum, if the court has an issue with it, it should be allowed to amend, but I don't think that's necessary here. This order should be reversed. Thank you for your time.
Okay, thank you both. All right, next this morning we have State Farm versus Markuson.